Hello everyone, welcome to Learn Law with AKP. In today's session, we are going to discuss an important topic from contracts to contracts of guarantee under section 126 of the Indian Contract Act 1872. This is a very important topic for exams and also very useful in practical life. In this session, we will understand the concept, parties involved, examples, and case law. So, let's begin. First, let's understand the meaning of contract of guarantee. A contract of guarantee means a promise to perform the obligation of another person in case he fails. This is very important. The responsibility arises only when the original person fails. So, we can say that guarantee is like a backup support. Let's take a simple example. If your friends takes a loan and you tell the bank, if he does not pay, I will pay, then you are giving a guarantee. So remember this clearly. Guarantee means taking responsibility for another person's failure. Now let's understand the parties involved. In a contract of guarantee, there are always three parties. First is the surety, the person who gives the guarantee. Second is the principal debtor, the person who actually takes the loan. Third is the creditor, the person who gives the loan. Let's take a bank example. The borrower is the principal debtor, the bank is the creditor, and the guarantor is the surety. So always remember, guarantee involves three parties. This is a very important exam point. Now, nature of liability. Now let's understand the nature of liability. The liability of the surety is called secondary liability. What does this mean? It means the surety is not responsible in the beginning. The surety becomes responsible only when the principal debtor fails. For example, if the borrower pays the loan properly, the guarantor has no role. But if the borrower fails to pay, then the guarantor must pay. So we can say the surety acts as a backup person. Now, the next question is, when does the liability arise? The answer is simple, only on default. Default means failure to pay or perform. So, if the principal debtor fails, then the surety becomes liable. For example, if EMI is not paid, the guarantor must pay. So remember, default is the trigger point. Now, let's understand the full process step by step. First, a loan is given by the bank. Second, a guarantee is given by the surety. Third, the principal debtor fails to repay. Finally, the surety pays the amount. This is how a contract of guarantee works in real life. This flow is very important for exams. Now let's understand an important case law. In Birkmyr with versus Darnell, one person promised that he would pay the debt of another person if that person failed. Now the question before the court was, is this a contract of guarantee? The court said yes, because it involves a person giving promise, another person who has actually liability, and a third person who will receive payment. So all three parties are present. The court clearly stated that if a person promises to pay the debt of another person in case of default, it is a contract of It is a contract of guarantee. So remember this in a simple line. Pay for another person is guarantee. Now let's quickly understand the difference from indemnity. In indemnity, there are only two parties, but in guarantee, there are three parties. This is a very important exams question, so don't confuse between indemnity and guarantee. Let's conclude this topic. A contract of guarantee is a promise to perform the obligation of another person in case of default. It involves three parties: surety, principal debtor, and creditor. The liability of the surety is secondary and arises only when the debtor fails. We also understood this clearly through the case of Birkmyr versus Darnell. So, guarantee provides security to the creditor. For exams, always remember definition, parties, example, and case law. Thank you. If you found this video very helpful, please like, share, and subscribe to Learn Law with AKP. Stay tuned for the next topic.